And welcome to the Special Committee on Impeachment Inquiry. It's been a little while since we've been together, June 27th to be exact, but today, July 24th, Monday, July 24th. And we have a couple matters to deal with this morning. I guess we'll go ahead. We're going to switch the order then as far as what is on the agenda. I have the matter of John Lavoie and the amendment to Rich Cassidy contract first, but we have Tim from DRM with us, so we'll jump to the 9:30 issue. And I know that we're waiting for one other individual, but if perhaps Michael O'Grady, if you can kind of just introduce us to what we are considering today, and then we will ask Tim and his other person when she gets on, fill us in a little more.
As you know, you entered into a contract with Downs Rackman Martin to conduct an investigation of the operations of the Franklin County Sheriff's Office by Sheriff John Grismore. As part of that investigation, you authorized subpoenas to be issued to the office, the Franklin County Sheriff's Office, for documents and other records relevant to the investigation. The sheriff, as I'm sure Tim will summarize, was not very cooperative in his response. Consequently, the subpoena needs to be enforced. And in order to enforce that subpoena, you need someone to represent you in court. The current contract with DRM doesn't contemplate that. And so what you would be looking at today is an amendment to the contract to allow for Downs Rackman Martin to represent the special committee in a subpoena enforcement proceeding.
Appreciate that. So I guess if we could start, Tim, by just if you could explain what kind of response we've received from, or you've received from Sheriff Grismore, just as a general matter.
Yeah, I'm happy to, Representative, and thank you for having me here. We issued the subpoena. We had the subpoena served a couple of weeks ago. We contracted with a process server. The subpoena was served. I received an email from Sheriff Grismore that I shared with Mr. O'Grady, who I believe has shared it with members of the special committee. He indicated that he wished to be cooperative and intended to be cooperative, but also indicated that the materials were voluminous that we requested, that it would take a considerable amount of time, and that he intended to seek counsel. We have not followed up with him with a follow-up response to that. But as you're all aware, open-ended declarations that subpoenas will be responded to, without a time frame is not the normal order of business. So we have proposed that we engage with the sheriff, hopefully be able to move toward a time frame that's acceptable to everyone, but that we also had to be prepared to seek enforcement of the subpoena if that wasn't something that we could work out with him. So that was the proposal that we made.
All right, I appreciate that. So I guess I do have just a basic question, and this may be more for legislative counsel. I know that Tim did send an email that laid out a game plan, essentially. I assume that that's something we want to keep confidential, or am I wrong, or does that not matter? I mean, it could be attorney work product, attorney-client privilege. Is that something that those details that we would want to keep confidential? And I can forward the email to the rest of the committee.
Well, as I think you just referenced, you have privileges and likely a statutory exception that you could assert to a Public Records Act request. If you think it's best for going forward strategy wise to maintain the confidentiality of that, I think you have the basis to withhold that document.
Right. And I'm just thinking that I assume, Tim, that we don't want to announce the strategy publicly that you laid out in the email, or is that something that's not
I think that that's right. I would be concerned about the email itself may not contain anything particularly earth-shattering, but Representative, I would be concerned about issues of sort of broader waiver if you sort of open the door toward DRM's legal advice to you. The email that I sent you, it is definitely, in my view, qualitatively different than an email in which we send to you in our strictly fact gathering role. That was legal advice that did contain my law firm's assessment of some particular legal issues. And if you want to maintain that privilege, I think you should, it's of course up to you, but I think you should consider strongly that approach.
Well, I think that this time we do, and I will forward this email, or Mike, if you could forward the email to the rest of the committee, just so you have it. But essentially, it just lays out the strategy for getting the documents that we need for the investigation from Sheriff Grismore.
That's correct.
So if individuals need more detail of what that strategy is before we vote on a contract amendment, we can do that in executive session. And at the end of the day, when we come out, or at some point during the day, we can come out of executive session to deal with that. But there are a couple other issues that we have. First of all, I know that to do the additional work is estimate of increasing the budget by $12,000. I have run that by the Speaker's office. We're okay with that budget increase, because this is additional work that was not contemplated under the original contract. So that's one issue. The other is a date, and what we are, I think, now seeing, perhaps not surprisingly, is that there are going to be delays that we don't have control over, or DRM doesn't have control over, that is from Sheriff Grismore's side. So obviously, we're not going to get the investigation at the end of this week. And the question I'm going to have is what kind of time frame, reasonable estimate do you have, Tim, as far as, given what you've already seen, given the response from Grismore, what is a doable deadline? Because that's another thing we need to have in this amended contract.
Representative, with all the caveats, there are a number of ways in which this could go. We could still, and the approach that I outlined to you and to Mr. O'Grady, does give us a pathway to obtaining these materials without litigation. I think that would be best for us for multiple reasons. But assuming that we did have to litigate this, I think we could be looking at a delay of multiple weeks, depending upon the Superior Court's schedule. And so I think that we would be, that's a delay in just getting the materials from the Sheriff's Department, not to mention then the analysis of them and then the follow-up interviews. And we really need to structure this in a way that we really need materials before we interview certain folks, in my judgment. So having said all that, I think if we moved forward into litigation in early August, and it was resolved sometime in August, and we were able to move quickly from that point onward, October, I think, would be a date that would be something that would be feasible if everything broke our way.
All right. So is that 1st of October or end of October or mid-October?
I would say mid-October.
Okay. So, I mean, that's fine. That's where we are. And just, I think, for the benefit of the rest of the committee, this is a discussion that I had with Mike, and I think it's fine to have it as a public discussion, that this is going to be, I anticipate that as we go forward in this investigation, it will be a little bit different than what we've been doing in the matter of State's Attorney Lavoie. I think that we will, because this is our investigator and we have a subcommittee that is meeting with them on a weekly basis, and we're able to discuss how the investigation's going, we're not going to have to redo all the ground of this investigation. Our primary, I anticipate that our primary witness for determining whether to bring articles of impeachment in the Sheriff Grismore case will be individuals from DRM, or I should say witnesses. There may be some additional witnesses we will have to take, but my point in all this is that I think once we get the report, it's going to be more expedited. We're going to be able to do this more quickly than we've had with the State's Attorney Lavoie, where we did not have, it wasn't our investigator, and we've essentially recreated and actually dug deeper than the investigation that was done by Paul Franklin Collins. So with a mid-October deadline, if we're actually able to meet that, we're still in a position, maybe it's not as quick as we want, but I mean, that's just the way it is. We're in a position to have articles of impeachment if that's the direction we go, perhaps even in the November timeframe. So I think that's just prognosticating a little bit there. So let's find a date in October to suggest. What do you have a date you would like to propose that we put into the contract, Tim?
I don't have a specific date, to be honest with you, Representative, but I mean, we could peg it right for the middle of October. We could say October 15th. I'm just going to check my calendar.
All right.
That's a Sunday. Do you want to just say,
Sunday.
you want to say the 16th?
I like the 16th unless we want to do Friday the 13th, but let's go to the 16th in case there's anybody who is concerned about such things.
Mr. Chairman, I want you to know, I think you may already know this, but when I first spoke with the speaker, I did not go to her. She came to me about being on this committee. And I told her that I would gladly serve on the committee, but that my husband and I have planned a trip to Ireland.
Okay.
We're flying October 17th. Okay. And we're coming back just before Thanksgiving. Okay. So we're going to be gone a while. Those kind of things are, do not even think to, obviously change those plans. So we can decide whether for the Grismore matter, whether we need to replace you for that matter, which, if it looks like, and this again, we may not actually end up having to report until you get back anyway, because I think what we just heard from Tim laying that out is that's like a best case scenario is October 16th. Did I understand that correct, Tim?
I think so. I understand. I very, very much understand the need to move this forward as quickly as possible for all parties. I think it's been a tremendous benefit to be meeting with the subcommittee every Monday. That way we can tell them directly what we've done the following week. But Representative, as you pointed out, there are things that are outside of our control, as it should be, frankly. There are other parties and other stakeholders who have rights, and so that is a date that I think is reasonable, but I do think that there are possibilities in which things could get delayed.
Right. Yeah, and again, we don't want to rush this either. I mean, we want to make sure that this is done right. And this is obviously very critical that we get this right. So it may end up not being an issue. And I think we will know well before, October 17th if we're on target for that date. And if we are, and if it looks like those weeks we really are going to try to do the Grismer matter, we can talk about it at that point.
All right.
So I appreciate you letting me know that. So any other questions on the proposed contract, or actually, why don't you, Mike, if you could just review this, because I think it's just Matt Kelly and I who have had a chance to see this, or actually another option is that, we can do those changes, put the date in, put the amount of money in, and we can give people a chance to look at it. And towards the end of the day, we can vote on the contract. Does that make more sense for folks? Yeah, just give people some time to actually really review it. But I don't think we'll have additional questions for Tim unless we want to plan on, do people want to hear the details beyond the email that Mike has sent you as far as the game plan? Because then we can plan on bringing Tim into executive session. We can. Yeah, okay. Yeah, I think that it's detailed. All right, so we won't need to ask you to come back, but I think towards the end of the day, or if there's another time where we have a break where we can come in out of executive session to vote on the amendment, we'll do it at that point. And if we have any additional questions, we can ask Mike about that. And if we need to track you down, we will. So,
of course, thank you so much. And it's been a pleasure speaking with you and working with you.
All right, thank you very much. Okay, so we will move back to the matter of State's Attorney John Lavoie. And you should have, actually, I think you did get the proposed amendment emailed to you a little while back. I can just find it. I printed it off today. Yeah, a nice piece. Fantastic. Yes, there we go. So everybody should have received this amendment, and I guess I'll just open it if there are questions about the proposed amendment. Yes, go ahead.
I want to be fair with this man. He has given us excellent service. My experience, though, Mr. Chair, is that $150 an hour is low ball. Does he agree to that?
Yeah, he has given us that so that we could be under the initial $10,000 cap. He agreed to that. He's essentially trying to cover his costs. I think he understands that this is a public service as well. But he has certain costs and he has, I think, very large opportunity costs by spending as much time in this. But I think he's very committed. He has communicated to me that he would do this. He would continue to help us without the contract amendment. I think that's very unfair. I mean, I think we need to at least have him cover his costs. I don't know. I think $7,500 is going to be more than enough because I think the work that I've started on this spreadsheet of evidence and that I know Karen is going to help me a bit on, and that was going to make the number of hours that he's going to have to put into this to help us prepare for other testimony is going to be, I think, expedited. So, yeah, I think his input has been very valuable, and I do want to make sure that he's at minimum covering his costs.
Yeah,
so
I agree, and I'm not one to spend money without cause. So I think you know that.
Right.
But I think that an average fair amount might be more like $300.
Yeah, I don't think that that's necessary to do that.
Okay.
I think you'd appreciate that, but we need to keep the cost in line. So
And Jill's okay with this?
I did, yeah, I've run this by the speaker's office.
Yeah.
Yeah.
All
Any
right.
other questions on this particular? Not seeing, I would take a motion to approve the contract, the amendment to the contract with Rich Cassidy Law for consulting services. So moved.
Second that.
Okay, all those in favor of approving the amendment? All right, excellent. So that's, let me make sure that I have everything that we needed to cover in open session. Yes, that is everything we need to cover in open session. So we do have some witnesses today, so I will take a motion to go into executive session in order to protect the witnesses' privacy for potential retaliation and to protect the integrity of our investigation. Is there a second?
Second?
Not that I know if we need seconds. Do we need seconds on such motions?
I don't know.
In any event, yeah, I see Mike is shaking his head, so we don't need the second. But in any event, all those in favor of going into executive session, please raise your hand. Any opposed? We're now in executive